Supreme Court of India Jafar vs State of Kerala decided on March 15, 2024 SEC Online SC 310 Facts of the case, on accused numbers 1 to 4, 6 and 7 armed with deadly weapons like iron lever and wooden bar, entered into the room number 17/1238. At the said gate, the security guard, prosecution witness 1, was posted. The appellant herein, accused number 2, kicked on the navel portion of prosecution witness 1. Sijo Fijo, accused number 4, beat him with an iron lever on the right leg, which resulted in fracture. Accused numbers 1 to 3 beat him with the wooden bar on various parts of his body. Thereafter, the accused persons tied the legs and hands of prosecution witness 1 with bath towels and made him lie on the cot. Following which, they fastened his body on the cot with a piece of bed sheet, and the remaining piece of the bed sheet was pushed into his mouth and they manhandled him. Thereafter, they committed robbery of mobile phone, wristwatch and torch belonging to prosecution witness 1 and destroyed the light in the building and lock of the shutters of the retail shop of the corporation. On the basis of said allegation, crime registered in police station for the offense punishable under Section 397 of the IPC. The charges under Section 397/395 IPC were framed. Trial court only found accused numbers 2 and 3 guilty and as such convicted them, and accused number 5 was acquitted. High court dismissed the appeal. Findings of the court: the conviction of the appellant herein is basically based on the deposition of Babu Puttan, prosecution witness 1, who was working as a security guard and was sitting in a chair in front of the said room. No doubt that he narrates the version, as per the prosecution case. He has also identified accused number 2 Jafar, appellant herein, and accused number 3 Sanish in the court. However, he has clearly admitted that police had shown him these two people, and as such, he has identified them. Anil Kumar, prosecution witness 8, who is the investigating officer, has also admitted that prosecution witness 1 identified the accused persons by seeing them at the police station. He has further admitted that no identification parade was conducted. As such, it can be seen that the identification of the appellant herein by prosecution witness 1 is quite doubtful, as no identification parade has been conducted. Prosecution witness 1 clearly states that he has identified the accused persons since the police had shown him those two people. In the absence of proper identification parade being conducted, the identification for the first time in the court cannot be said to be free from doubt. We find that the other circumstance that the courts relied for resting the order of conviction is with regard to the recovery of an iron rod. An iron rod is an article which could be found anywhere. It is not the case of the prosecution that any stolen article was recovered from the appellant herein. The appeal is therefore allowed. The judgment is quashed and set aside.